Well, hello, we're back again, and now we're going to begin a discussion on agency. Agency in Illinois has been, we were actually kind of a leader across the country in real estate agency. Way back in the mid-90s, we were the first state to really establish designated agency as the agency law for the practice of real estate. And so the purpose of that is so that the consumer of our services, our brokerage services, understands exactly who is representing who within that transaction. And that's basically the nuts and bolts of agency. Because along with these agency duties or non-agency responsibilities that are laid out in the law, we have certain things that we have to provide to our clients who we represent and also to our customers that we don't represent. So with that, what I'd like to do now is to have you watch a video that Lynn and I have put together concerning some agency issues that we've gone through and we see happening out here in practice, and further define what our role is and what these proper disclosures are as it pertains to agency and our relationships with the consumer, either a client or a customer. Lynn, how are you today?
I'm good. Good to see you.
Good to see you. We're going to speak a little bit today about some agency issues where there's some confusion, I think, and has been for a number of years. Typically, we've had designated agency now for, I counted it the other day, 24 years.
Wow.
And there's still some confusion out there.
Yeah.
And one of the biggest things, I think, where there is confusion is the whether or not, when and how and all this other about when do you have to make this agency disclosure and why is it important? You want to talk a little bit about that?
Sure. So we need to do the what, when, why, and how of designated agency disclosure.
Yeah.
I think one of the first problems we have is that I don't know that we as agents always understand how the consumer looks at this. Typically, when you hire a company to do work, everybody in that company works for you. So the consumer hires somebody to put a new roof on. Everybody who comes to work on that roof works for the same company. That's not how it works with designated agency, as you know.
Especially with the independent contractor situation we've got and everything else.
Of course.
Yeah.
So I have a listing. I am the agent of the seller. I'm the only one in our whole company that works for the seller. The rest of you guys, assuming you and I are in the same company, you don't work for my seller. So I have to make sure my seller knows that they should not be sharing any confidential information with you. It's even more critical on the buy side, because a lot of times then when the buyers put an offer in on a piece of property, they just go spouting off to people and talking to them about, what do you think about this property? Was this a good price, etc. And the rest of the agents in my office do not work for them. But the other problem that we're running into is that our agents don't always incorporate the designated agency disclosure in a normal kind of flow with their listing and their seller and buyer counseling session.
I agree. And one of my favorite questions is, and I know I've talked to you about this before, but I like to get into a CE class or anything when we start to talk about agency, and I'll say, I'd like to start with asking this question. When you go on a listing presentation, are you the agent for that seller on a listing presentation? And better than half, probably 3/4 of them always say, nope, not yet.
Yep.
But then my next question is, how many times have you gone on a listing presentation and not gotten confidential information from that seller? And it's like, well, never. And I said, well, then you are their agent.
Yes.
And I think that because usually the triggering event is that disclosure of confidential information and our duty to protect it. So It's kind of interesting.
Well, and that's exactly what our case study,
Yeah.
that's exactly what our case study covered, and you're absolutely right. If I didn't go in with that seller and give them a notice of no agency form and read them, if you will, their Miranda rights of real estate, I don't work for you, do not disclose anything to me, you don't want to disclose me to disclose to somebody else, then I was the agent of that seller.
Well, and the thing of it is, I said you have two options.
Yep.
You either are their agent or you're going to give them a notice of no agency.
right.
And so you're going to walk in the door to get a listing and say, oh, by the way, I'm not your agent yet, and don't tell me anything you want me to disclose to anybody else.
Right.
That's not going to work.
Well, and I
You
don't
know,
even
so-
know. I don't even know how you can do a good listing presentation by doing that.
Oh, you can't. And that's my point.
I need to know why they need to sell, when they need to sell. I can't formulate a marketing plan for them if I don't know all of that. And I
Correct.
shouldn't know all of that unless I'm their agent.
Or
So
what
it's-
are their expectations
That's
on
right.
price
That's
and
right.
everything else? So yeah.
one of the easiest things to do for our agents is for them to just presume when they go on that listing presentation.
what the
that
license law
they are-
says.
That is absolutely right. So again, this is a really good example, I think, of just incorporating all of this agency disclosure into our daily practice. When we meet that buyer for the first time and we're talking to them about their wants and their needs and have they talked to the lender and all the rest of that, we should normally just be incorporating the agency disclosure into
Well,
that.
and then, this always happens. You either get a phone call on one of your listings that, hey, somebody's interested, they want to see the property. Well, for years we've had agents running around out here and they think showing the property is what did they call that, Lynn? A ministerial act.
There you go. Let's talk about that a little bit.
Yeah, so go ahead.
Well, we had something in our license law, as most of us know, up until just now, almost, that was called ministerial acts. And it was really there to give an example of what we could do for a consumer if we were not their agent.
Without any disclosure.
Without any disclosure.
Right.
Well, the problem was we had too many people going too far with that.
Right.
We had, unfortunately, a couple of people who felt that now means that I can have a buyer go sell them ABC's listing and not represent anybody. None of that was true. So we've taken ministerial acts totally out of the license law now.
And
but you
yeah.
can still have a buyer, you can still sell your own listing. For example, if you had a seller who said no to dual agency, you could still have a buyer who is your customer, not your client, sell them your own listing. You're doing no agency with them. Just stop thinking about ministerial acts. Just look at it as no agency.
Right, because there used to be one of the examples they had given was completing the form on behalf of your client
Right.
for a customer. And, I think everyone thought that this ministerial acts was just something that happened and you have to worry about disclosure and
Right.
all of this. So specifically now, I think under the new law with that removed, which you and I agree that it was always there.
Yeah.
But I think that why they put those in there, I don't know, but we weren't there when they did it. But the whole point of it is that you have to give some sort of written disclosure
Right.
basically on first contact. Now, the other thing that you and I have talked about over a number of years is, yes, there are still times somebody calls you up on the phone and they ask you about the price or location of a
Right.
property. It's very benign. You hang up the phone, it's over, it's done. There was never any expectation on the part of that consumer
Right.
or confusion. But when you start really working with somebody on a transaction or showing property, they have to know whether you are or are not representing them.
That's right. And one of the reasons for that is that it's so normal in most cases for a buyer to say, boy, I love this house. We think we're going to offer $250,000. We'll go as high as $275,000, but do you think the seller will take $250,000? If I'm a dual agent showing my own listing, then I keep all of that confidential. I don't
Sure.
have to tell my seller that this buyer said he'd go to $275,000. If this buyer is not my client, if this buyer is a customer, I should have given him the notice of no agency form. I should have told him not to disclose any of that to me. Because at that point, if he's not my client, and he says, we want to start at $250,000, we'll go to $275,000, I am legally obligated to tell my seller that he said he would go to $275,000. That's why the buyers and sellers need to know about the
And,
agency.
you know, the other thing is I think we've all fallen into this trap, or many have, where, you know, we have wonderful forms that the Illinois Realtors and a lot of other people have devised for us. And they're great forms, but that's not the end all be all.
Correct. Yeah.
You know, when you make these disclosures, you should also explain to your client, whether it's buyer, seller, tenant, landlord, what it means when you represent, what it means when they are a customer and you don't represent. And that's where I think a lot of that confusion comes in.
We've had people who have just had the buyer or the seller sign the form and then go off and act in a whole different direction because they think it was the form that saved them. The form won't save you. It's what you do that's important.
And, you know, I mean, I've been involved on the regulatory side of this, and, you know, they'll sit there and they go, well, I gave them the disclosure, but your actions were this way, the disclosure was this way. And, you know, so even though you made the disclosure, you not only have to make it, explain it, live it.
Yeah, and a lot of people aren't.
Yeah.
I just wanted to briefly talk about our situation case study number 2 that we had in there, which I think sometimes it gets a little confusing to some people. We have something in Illinois called minimum services, and minimum services, as most of us know, means that if I have an exclusive agreement with a buyer or a seller, and let's use a seller in this case.
Or a tenant or a landlord.
Oh yeah,
Doesn't matter.
Doesn't matter. But if I have an exclusive agreement with a seller in this case, and I put them into the MLS, I am supposed to still be involved with the presentation and negotiation of their contracts, be available to them for the answering of all questions all the way through to the closing. And unfortunately, we have in many areas of the state, we have brokerage companies who seem to be violating the license law. They're taking these listings, putting them in the MLS, and when an offer comes in on the property, they are, abandoning their sellers. They're not involved at all in the negotiations, which puts the buyer agents in a mess because the buyer agents are now negotiating their contracts directly with somebody else's listed seller. So I just wanted to make sure that we talk a little bit about why we put this situation number 2 in here. When you go to present an offer directly to somebody else's listed seller, you are not their agent, but the seller thinks that you are in most cases. They're paying you because that's just the way they set it, the listing office set it up. And you're negotiating the contract, and in that case, when the seller says, well, we'll take this $250,000, but we're going to counter back at $260,000. So go see if the buyer will go to $260,000. You don't work for the seller. You are now going to go back to that buyer and say they're countering at $260,000, but they told me they would take the $250,000. The license law does not require you to give that seller the notice of no agency form. We are recommending for your sake that you do give them a notice of no agency form. However, you do not have the obligation to explain to them what that means. I know this sounds awful, but I work for the buyer. I do not have to sit down with Norm Seller and say, Mr. and Mrs. Seller, by the way, do not disclose anything to me that you don't want my buyer to know. I don't think we have to go that far. I just have to give them the form.
You know, and it's very similar to the for sale by owner.
Yes.
You know, where you've got a buyer and yes, they want to buy that for sale by owner. And one of the ways I've always explained it, you have some options. You know, you can go to that seller and say, okay, if I sell your property, will you pay me? And by the way, I'm not representing you, I'm representing the buyer, and I'm going to give them a notice of no agency. Or, you know, you can enter into an agreement and then you become a dual agent, you know, if that's the way it works out. But you have options. But, you know, of course, my theory is those for sale by owners think they're smarter than us anyway, so let them represent themselves, and we'll represent our buyer. So, and I'll take their money.
And the bottom line is the same thing's happening here. This is a seller who doesn't always understand what's going on. So that's the only reason that we recommend it. Again, nothing in the license law that requires you to do this, just a good healthy dose of common sense and a preventative dose of somebody accusing you of of violating your fiduciary duties, statutory duties, when you don't even have any?
Well, off and on for 25 years, I've been involved in regulation of real estate. And one of the things I always said, if I've sat in hearings and informal hearings and just sat down in discussion with people that have complaints filed against them. And I said I always like to have $5 for every time somebody said to me, well, I've been doing it that way for 20 years and never had a problem. And my analogy to that is you have a driver's license. And I guarantee you, when I drove up here this morning, Lynn, I broke the law. I was speeding.
Oh, no. I never do that.
But I was taking a calculated risk that I wasn't going to get caught. And it's the same thing with your license, you know, your real estate license. You could go along your merry way for 20 years, never make these disclosures and never have a problem. But boom, once there's a complaint filed, and I guarantee you, prosecuting attorneys and investigators, they will ask you for your agency disclosure.
I do expert witnessing in trials where realtors are being sued, and it comes up every single time.
Right.
They want the agency disclosure. So it's something we all need to be very careful of, and I hope that our little discussion here helped you all realize how important it is that you do your agency disclosures and how you can incorporate it into your normal counseling sessions with your buyers and sellers.
Yeah, everybody has to have a technique and a way to do it, and it's not comfortable when you're first meeting with it. It has to be done.
Got to be done.
Yep.
Please pause the video, go back to your coursework, go to the agency module, and take the agency quiz. When you're done and have submitted the quiz, you will return to the agency video guide.
All right, now we're going to go over the agency quiz. And our first question under agency is, according to the Real Estate License Act of 2000, the purpose of Article 15 is to govern the relationships between licensees and consumers. And the correct answer is true. That's basically the basis for it. Illinois was the first state that adopted designated agency as the agency required for real estate licensees. So it's kind of an interesting concept, and now probably better than half of the states and their real estate regulation in the country have adopted pretty much the Illinois model. All right, let's go to agency question number 2. A licensee is considered to be the designated agent of the person they are working with unless they have a written agreement to the contrary. And once again, that is true. So in other words, what this does, there is a presumption of agency in Illinois. So when you begin to work with someone, you are pretty much considered to be their designated agent. And the reasoning behind that is so that the consumer is protected, that if they divulge or give you any confidential information, you have a duty to protect that. Now, the only thing that would relieve you of this designated agency relationship is if you give them something in writing, and it says to the contrary, which is what the Act says. But basically, that would mean that you would have to give them a notice that says, I am not your agent, or commonly referred to as the notice of no agency relationship. So it's important to understand that this is a clear indication in the Act that you will create designated agency when you begin to work with someone, unless you give them a written notice that you are not. And you should also warn them not to disclose any confidential information to you if that is the case. Number 3, a licensee may disclose confidential information received from a client after the termination of the brokerage agreement, and that is false. The protection of confidential information is forever. Now, there's only 3 different ways that the Act talks about that you can release confidential information. The first one being that the client that gave you that information has determined that it's okay for you to tell someone else. Now, that may be specific, it may be public, but in other words, you have been granted permission to disclose that information. Now, an example of that would be if you had a listing agreement and you listed the property at $199,000, but your seller has told you confidentially that they actually would accept $190,000. So if you get an offer, and let's say they offered $185,000, and now the seller tells you that, hey, go back and counter back to them that $190,000 is my bottom dollar. Well, now you can release that, and it's other than the listing price. Okay? So number 4, a licensee must discuss with a client the sponsoring broker's compensation and policy when cooperating with brokers representing other parties in a real estate transaction. And that is absolutely true. So in other words, when you create a designated agency relationship and you have given written disclosure of that designated agency relationship with a client as required by the law, then you also should discuss with them what your expectations are on compensation, and additionally how you will cooperate with other brokers and sponsoring brokers and agents of those sponsoring brokers representing other parties. In other words, if you agree to share the commission that you will collect off of your client with another brokerage firm, then you have to disclose to your client what that policy is. Okay? And the final question in agency: an action may be brought against the licensee for failing to disclose that a person who was residing in a home was afflicted with HIV. And that is false. And in fact, the Article 15 provides a little bit of protection here for the licensee in that that it basically states that no action shall be taken against the licensee for failing to disclose issues that are not what we call physical defects in the property and are otherwise determined. So some of these examples would be that there's a murder or a suicide and those kind of things. Those things are absolutely, you're not required under the law to disclose them. Now, in fact, you may, but the point of it is the law basically says that they can't come back on you for failing to disclose those non-physical defect issues. You know, murder, suicide, ghosts, person with HIV, those kind of things. So those are commonly referred to as stigmatized property issues. Okay? So that completes our agency quiz. I appreciate it, and we'll be back in a few minutes. Thank you.
You can now close the agency video guide and return to your coursework. Go to the advertising module and read the 2 pages on advertising. When you've completed the 2 pages of reading, please play the advertising video guide.